Welcome to the ACS Nashville Chapter's annual U.S. Supreme Court preview, featuring ACS friend and current Board of Advisors member, Erwin Chemerinsky. I just saw Erwin recently at Berkeley, at the law school there, and he has this great new book out about qualified immunity, so I think this is just terrific. My name is Russ Feingold, and I am president of the American Constitution Society. I want to start by spotlighting today's organizers. Thank you to James Davis and Will Mazzota, the ACS Nashville Supreme Court co-chairs, and Grace Straunch, the ACS Nashville president, for their tireless work in organizing this wonderful annual event. Thank you also to a Board of Advisors member, Erwin Chemerinsky, for taking the time to speak at the event. As you may know, the American Constitution Society is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers, judges, and advocates, and ensuring that the law is a force for improving the lives of all people. As part of that work, and in honor of our anniversary, we've been exploring the founding failures of our Constitution, particularly as they relate to race and the law. We recognize that racial inequity isn't just rooted in the history of this country, it's rooted in and sustained by our laws and legal systems. That's why at our national convention this year, we announced our support for truth, racial healing, and transformation in the United States. We think it's particularly important for the legal community to be active participants in and supporters of truth, racial healing, and transformation because of how much of the history and infrastructure of white supremacy is intertwined with that of our laws and our judicial system. It is past time for our profession to help detail and rectify the harms inflicted by the system our laws contribute to and sustain. Now, I could not be more proud of how our chapters have stepped up to engage with initiatives that aim to reckon with state and local laws and histories and to explore opportunities for redress and restitution. While we are approaching the end of our anniversary year, we are committed to continuing this work in the months and years to come. And a part of reckoning with our past for a more just future is finally achieving a judiciary that reflects the diversity of the public it serves. One of our core tenets as an organization is that courts matter, and we know who sits on our courts matter. Right now, our courts are overwhelmingly white and overwhelmingly male. ACS is on the front lines of changing this with our Path to the Bench project. Our 53 working groups across the country, including this great Nashville working group, have identified diverse candidates in their states and local communities and have built a national pipeline of progressive and diverse candidates for the federal bench. We are prioritizing racial, ethnic, gender, LGBTQ+, and professional diversity with the goal of finally achieving a judiciary that reflects the public it serves. And as one of the only groups that has delivered names from a nationwide grassroots effort, we are confident that our diverse progressive judicial candidates are being well received by the White House and by senators. So I'm so proud of our network, of our pipeline, and of the results we've already seen. In its first 100 days, the Biden-Harris administration and the Senate confirmed more judges than the previous two administrations combined. Just as importantly, this administration has also shown an unparalleled commitment to nominating diverse candidates. So far, the confirmed judges under this administration have been majority women and majority people of color. We're also seeing great professional diversity. Our work is proving to be instrumental in diversifying our courts. And this is a credit to our members and to our network. I'm grateful every time I have the opportunity to speak to one of our chapter events like this, because it's an opportunity for me to applaud the work of our chapters and the incredible progress that ACS is achieving year in and year out. So thank you all for attending today's Supreme Court preview. As you know, Dean Chemerinsky will explain shortly, there is so much at stake this term, including reproductive rights and the right to bodily autonomy. This is particularly true because we no longer have a Supreme Court that we can trust to uphold judicial norms and constitutional rights. This packed court has shown an unparalleled willingness to abandon its own precedent in pursuit of a political agenda. That's why ACS is advocating for both structural and non-structural Supreme Court reform to restore the credibility of our highest court and to protect our democratic legitimacy. We hope that you'll continue to support our work in these different areas by attending future events, by engaging with us both locally and nationally, and by donating to ACS using the link in your chat box. So I will now turn things over to our Nashville Lawyer Chapter leaders. Thanks so much.
All right, well, thank you to Senator Feingold. I'm James Davis. I'm one of the co-chairs of the Supreme Court preview this year. I'd like to welcome everyone and thank you for attending. I just got a few notes before we get started. First, as you've probably seen in the emails, this event's been approved for 1 hour of CLE with Tennessee. So you should get an email after the program with instructions for reporting that attendance. And that we're in a Zoom webinar format. So if you want to communicate with us, the way to do that is to use the Q&A button at the bottom of the screen or at the edge of the screen. If you have any questions for us, you can put those there. And if you have questions for Dean Chemerinsky, we'll have a Q&A session at the end. So you can put those questions in that box also. And we'd like to express our sincere thanks to all the sponsors of the event this year. At the benefactor level, we have Leif, Cabraser, Hyman, and Bernstein, and Sherrard, Rowe, Voigt, and Harbison. At the donor level, Compassion and Choices, Branstetter, Trench, and Jennings, and the Tennessee Trial Lawyers Association. At the friend level, Bassberry and Sims and the Higgins firm. Community sponsors were the Southern Environmental Law Center and ACLU of Tennessee. And we had individual sponsors as well, Tracy George, Gregory Ramos, and Grace Straunch. And so Grace is our chapter president, and so I'll hand it over to her now to introduce Dean Chemerinsky. Thank you.
I am so incredibly honored to introduce one of my personal legal heroes, Dean of Berkeley Law, Erwin Chemerinsky. When we announced him as our speaker, I received so much correspondence from lawyers excited to hear from the individual who helped them pass constitutional law. He gives so much time to improving the legal community and to ACS as one of our National Board of Advisors. His accolades and published work are so extensive, it would likely take most of the event for me to list everything. But I did want to make sure that everyone was aware of his latest new book, Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. I know everyone is so excited to hear Dean Chemerinsky speak, so I'll go ahead and pass it to you. Thank you.
Grace, thank you so much for the kind introduction. I want to thank the Nashville chapter of ACS for inviting me. I wish we could be in person, but I'm glad at least we can gather this way. I think it's important that we regard the current court as the culmination of a half-century effort by conservatives to create a staunch conservative majority among the justices. Richard Nixon ran for president in 1968, largely against the liberalism of the Warren Court. He said he was going to appoint strict constructionists committed to law and order. When Ronald Reagan was inaugurated in January of 1981, he was explicit in his desire to move the Supreme Court and the lower federal courts much further to the right. When Donald Trump ran for president in 2016, he said he would appoint justices committed to overruling Roe versus Wade. He got to pick 3 justices. The result is that right now we have the most conservative court that there's been since the early 1930s. If you think of it as an ideological continuum, there are 5 staunch conservatives in Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. A solid moderate conservative in Roberts. He's right of center, though not as far to the right as those other justices. 2 justices who I regard as moderate liberals, Breyer and Kagan, but only 1 staunch liberal, Sotomayor. There were 2 until Justice Ginsburg passed away. How did we get here? Between 1960 and 2020, there were 32 years with Republican presidents and 28 years with Democratic presidents. It's almost even. In fact, in 2024, it'll be 32 years with a Republican president and 32 years with a Democratic president. But between 1960 and 2020, Republican presidents picked 15 Supreme Court justices, and Democratic presidents picked only 8 Supreme Court justices, almost a difference of 2 to 1. When Justice Barrett was confirmed for the Supreme Court on October 26, 2020, I made 2 predictions about that term of the court. First, we'd see a lot more 6-3 decisions. There's now 6 conservative justices, and only 3 liberal justices. We saw that exactly last year. There were 12 6-3 decisions and 6 5-4 decisions. Some of the most important rulings of the term, like the voting rights case, were 6-3, divided along ideological lines. My other prediction is we would see very few 5-4 cases with the liberals in the majority. Simple arithmetic explains why. Now for the liberal justices to be a majority, they need to get 2 votes, not just 1, and 2 on a court that has 5 staunch conservatives. There were no decisions last year that were 5-4 where the liberals were in the majority. I think it's important to recognize that this is not a short-term phenomenon. When Justice Barrett was sworn in a year ago, she was 48 years old. She remains on the court until she's 87. The age was Justice Ginsburg died. Barrett will be a justice into the year 2059. When she was sworn in, Neil Gorsuch was 53, Brett Kavanaugh 55, John Roberts 65, Samuel Alito 70, and Clarence Thomas 72. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. For all, John Paul Stevens didn't retire until he was 90. So it's easy to imagine 5 or 6 of these justices be together for the next decade or 2. My task is to preview for you the most important matters than the Supreme Court's docket this term. If I was to pick one word to describe October term 2021, it would be blockbuster. Decided to organize the topics alphabetically, and then of course save a few minutes for questions. So I begin with what I think this term will be most known for. It's abortion cases. 2 of the cases were argued on Monday, November 1st. The other was argued a week ago today on December 1st. The 2 that were argued on November 1st involved a Texas law, SB 8, that prohibits abortions after the 6th week of pregnancy. That's clearly unconstitutional. Roe v. Wade, Planned Parenthood v. Casey say that states can't prohibit abortions before viability. That's about the 24th week of pregnancy. The Texas law is unusual in that it's enforced not by government officials, but by private civil suits. It says that doctors who perform abortions or those who aid or abet abortions can be sued, and the plaintiff can recover $10,000. A lawsuit was brought by a reproductive health care facility, Whole Women's Health, to seek an injunction of the law. The federal district court granted an injunction. The Fifth Circuit reversed, and it came to the Supreme Court for a preliminary injunction on Wednesday, September 1st. That was the day the law was to go into effect. The justices 5-4 denied a preliminary injunction. The 5 in the majority were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. They said there's an unusual procedural aspect of the law, so they wouldn't grant a preliminary injunction. Chief Justice Roberts, along with Justice Breyer, Kagan, and Sotomayor, vehemently dissented. After this happened, the United States government filed a lawsuit to challenge the Texas statute. It said that it was doing so to uphold the sovereign interests of the United States and protect the constitutional rights of women in Texas. A federal district court judge in Texas, Judge Pittman, in a 113-page opinion, ruled in favor of the United States. It said the United States had standing to sue. It said that the United States had a cause of action to sue for equitable relief, granted the preliminary injunction. The Fifth Circuit 2-1 stayed the preliminary injunction pending briefing and oral argument in the Fifth Circuit. On October 21st, the Supreme Court granted cert in both of these cases, Whole Woman's Health versus Jackson and United States versus Texas. The court scheduled oral arguments for November 1st. Both involve procedural questions. As to the former, can there be a suit for injunctive relief against state officials if they play no role in enforcing the law? As to the latter, can the United States government bring suit on behalf of the residents, the women in Texas? These cases await decision, though neither is directly about whether to overrule Roe versus Wade. That's in the background. And the court last Wednesday heard the case that directly poses the question of whether Roe will be overruled. Dobbs versus Jackson Women's Health. It involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. Again, since viability is about the 24th week of pregnancy, this is clearly unconstitutional. Most striking to me at the oral argument last week is how clear Chief Justice Roberts and Justice Kavanaugh and Barrett were as to what they want to do with regard to this case. We knew going in that Justices Thomas, Alito, and Gorsuch would vote to overrule Roe versus Wade. But there was thought maybe with regard to some or all of these three justices, and we hope they might go that far. Justices Kavanaugh and Barrett left no doubt they'll vote to overrule Roe. Justice Kavanaugh in his question said that he believes it's an issue that should be left to the political process. Justice Barrett in several questions said she believes that laws prohibiting abortion are not an undue burden on women, and I'm quoting, because they put the baby up for adoption. Chief Justice Roberts made clear that he would like to uphold the Mississippi law without taking a position about laws that prohibit abortion even earlier in pregnancy or whether to overrule Roe. So, what can we say about Dobbs after last Wednesday's oral argument? I think it's a question of how the Supreme Court is going to uphold the Mississippi law. I can't count 5 votes to strike it down. I think one possibility is that the court will overrule Roe versus Wade and leave abortion entirely to the states. The other possibility is the court will uphold the Mississippi law, but say nothing about laws that prohibit abortion earlier, like the Texas law at 6 weeks of pregnancy or the Alabama law that prohibits abortion from the moment of conception. I was surprised that the Supreme Court handed down decisions on the 2 Texas cases that were argued on November 1st. After the arguments last Wednesday, I began to wonder, will the Supreme Court in Dobbs overrule Roe, hold that the Texas law is constitutional, and say that therefore the issues that were raised in the 2 Texas cases, procedural issues, are moot? But the law with regard to abortion is about to change and change dramatically. It's going to be that states able to regulate or prohibit abortion however they want. I estimate between 25 and 30 states will prohibit all abortions. States like California and New York will continue to allow abortions. Women who have the money in the states where abortion is illegal can travel to the states or the countries where abortion is permissible. But poor women, teenagers, again will face the cruel choice between an unsafe back alley abortion and an unwanted child. The second area that I list concerns civil rights. And by the way, I did prepare a handout that lists the cases in the order in which I'm going to be discussing them, and hopefully that's available to you. One civil rights case I want to talk about has not yet been decided, Thompson versus Clark. In Heck versus Humphrey, the Supreme Court held that a person who's been convicted of a crime cannot bring a civil suit that be inconsistent with the conviction until the conviction is overturned, such as on appeal or on habeas. So if a person's been convicted of a crime, they can't sue the prosecutor for malicious prosecution. But what if the person hasn't been convicted? What if the government drops its prosecution? That's Thompson versus Clark. Larry Thompson and his wife had a new baby. The baby was a week old. Thompson's sister-in-law was staying with them. She obviously had mental illness. She called 911 and said she thought the newborn baby was being sexually abused. The baby's buttocks were red. EMTs came. Larry Thompson said, "You're in the wrong place." They came back a couple hours later with the police. Thompson said to the officer, "You can't come in unless you've got a warrant." The officer pushed in the door, shoved Thompson to the floor, and they took the baby. The baby went to the emergency room. There was no evidence of sexual abuse or abuse of any kind. The baby had diaper rash. Thompson was charged with resisting arrest and obstructing a police officer in the performance of duties. The prosecutor decided to dismiss the charges. The prosecutor said to the court, the charge was being dismissed, quote, "in the interest of justice." Thompson then sued the prosecutor for malicious prosecution. The federal district court in New York said, "I know this sounds absurd, but you can't bring a civil suit to challenge a prosecution unless you can show an affirmative indication of actual innocence." There was never any court that found Thompson innocent, so he couldn't sue. The Second Circuit affirmed, and the Supreme Court granted review. We don't have a mechanism in our society for courts to declare someone innocent when charges are dismissed. If the Supreme Court says this is precluded, if anything, encourage prosecutors to bring charges as a way of protecting themselves from civil liability. The case was argued on October 12th. There were two civil rights cases that have already been decided by the Supreme Court. Both involved qualified immunity, and both are of concern. As you know, whenever a government official is sued for money damages, there's always an immunity defense. Some government officials have absolute immunity. Prosecutors for their prosecutorial tasks, judges for their judicial tasks. All government officials who do not have absolute immunity have qualified immunity when they're sued for money damages. The test for qualified immunity comes from Harlow versus Fitzgerald in 1982, though it's been reformulated by the court since. And it says that a government official can be held liable only if he or she violates clearly established law that every reasonable officer should know. The Supreme Court says the right that is to be established beyond debate. There's been a great deal of criticism of qualified immunity from both the right and the left. Many thought that, especially in light of this and the racial reckoning, the Supreme Court might be more lenient, more favorable to plaintiffs with regard to qualified immunity. Two cases, both involving excess of force, were decided by the Supreme Court on October 18th. Both are per curiam, both were unanimous. The first was Rivas Vegas versus Cortisoluna. Involved a domestic dispute. The police came in response to a call. They told the man to come out with his hands down. When he raised his hands, the police fired a beanbag shot at him. And then the officer roughly pushed the man down and put his knee hard on the man's back. The officer did this with enough force to cause damage and injury. The man sued the police officer for excess of force. The federal district court found qualified immunity, but the Ninth Circuit reversed. The Ninth Circuit said whether the officer here used excessive force in putting his knee on the man's back was a matter that the jury should decide. The Supreme Court unanimously reversed. The Supreme Court emphasized the absence of a case on point in saying there's qualified immunity. The court said, and I quote, "Even assuming the controlling circuit precedent clearly establishes law for purpose of 1983, prior decisions did not give fair notice to Rivas Vegas, the police officer." The court said, "Neither Cortisoluna nor the Court of Appeals identified any Supreme Court case that addressed facts like the one at issue here." The other case, City of Tahlequah, Oklahoma versus Bond, had even more tragic facts. Again, it arose in the context of a domestic disturbance. The police came when a woman called the police on her ex-husband. When the police arrived, he was in a tool shed, a garage area, and the man picked up a hammer off the shelf and held it up. The officer then shot and killed the man. The man's estate sued the police for using excessive force. The federal district court ruled in favor of the officer based on qualified immunity. But the United States Court of Appeals for the 10th Circuit reversed. The 10th Circuit found that the shooting was excessive force and there was no qualified immunity. The Supreme Court again unanimously, again in a per curiam opinion reversed. And once more, the court stressed the absence of a case on point. The court said, and I quote, "Neither the panel majority nor the respondents have identified a single precedent finding a Fourth Amendment violation under similar circumstances. The office thus entitled to qualified immunity." If the courts insist on a case with identical facts, office will so often be protected by qualified immunity. And it's troubling that the Supreme Court's decisions here stress the absence of a case on point as a basis for qualified immunity. The third area I want to talk about concerns criminal law. The Supreme Court is deciding fewer and fewer cases each year and fewer criminal cases. 2 years ago, the court decided only 53 cases with signed opinions after briefing and oral argument. There's the fewest number since 1862. Last year, the court decided only 54 cases with signed opinions after briefing and oral argument. And interestingly, last term, only 4 were reviewing state court decisions. One major criminal law case I would mention this term, and that's United States versus Tsarnaev. It arose from the tragic bombing at the Boston Marathon in 2013. Tamerlan Tsarnaev and his younger brother, Dzhokhar Tsarnaev, planted bombs that killed 3 people and injured hundreds of others. Tamerlan Tsarnaev was killed by the police in a shootout. Dzhokhar Tsarnaev was arrested and prosecuted. Dzhokhar Tsarnaev's lawyers moved to change venue. They said there's been so much publicity in Boston, it's not possible to get a fair jury. The judge denied the motion for change of venue. The judge said he would hold an intensive questioning during voir dire. During voir dire, the defense wanted the judge to ask all the jurors what they had seen and heard about the case and any conclusions they came to. The judge only wanted to ask if they'd made up their mind in terms of the defendant's guilt, and if so, whether they could still be open-minded. The defense thought that was not nearly enough to ensure a fair jury. 4 times they moved to change venue. 4 times that motion was denied. Voir dire took 21 days. The jury was impaneled, the trial occurred, Tsarnaev was convicted. In the penalty phase, Tsarnaev's lawyer wanted to introduce evidence of another murder that was committed by Tamerlan Tsarnaev. This was part of showing that Tamerlan was a murderer and the one really responsible for what went on at the Boston Marathon. The judge refused to allow that evidence in. Tsarnaev was sentenced to death. The United States Court of Appeals for the First Circuit reversed the death sentence on 2 grounds. First, there was not adequate questioning of the jury during voir dire. And second, the judge should have allowed at the penalty phase the evidence of the other murder committed by Tamerlan Tsarnaev. The Supreme Court held oral arguments on October 13th. I thought the oral argument would focus much more on the first question, because one that arises more often, what kind of questioning of voir dire should occur in high-profile cases. But in reality, the oral argument focused entirely on the second question. My sense from the oral argument is that the justices are likely to reverse the Court of Appeals and reinstate the death sentence. One interesting thing here. The First Circuit overturned the death sentence. It did not overturn the conviction. In June of this year, Attorney General Merrick Garland announced a moratorium on the federal death penalty. It's interesting then that the Biden administration, notwithstanding this moratorium, chose to appeal this to the Supreme Court. Justice Barrett raised this at oral argument. She asked if the Supreme Court were to reverse and reinstate the death penalty, what would the United States government do? And the Solicitor General said, carry out the death sentence is imposed by the court. So there is a tension between the position of the Biden administration and the appeal of this case to the Supreme Court. The next area I want to talk about concerns freedom of speech. And there are 3 speech cases on the docket this term. Probably the least important of them is Houston Community College System versus Wilson. What's involved here is there's an elected board of the Houston Community College System. One member of the board was disruptive, and the member of the board got censured by his fellow board members. he sued and said that this censure violated his First Amendment rights. He said he was being censured for his speech. The United States Court of Appeals for the Fifth Circuit ruled in his favor, and the community college system, the board appeals, gets certiorari from the Supreme Court. I was surprised the Supreme Court took this case. After all, if the court is deciding just 50 or 60 some cases a year, you'd think they want to take issues of national importance where there's a split among the circuits. And this isn't that. I think there's a certain number of cases each term that the court takes just for error correction, because they perceive the lower court to have made a mistake. And I think that's what happened here. The oral argument indicated, I think, that the Supreme Court's going to say that the board members passing a censure resolution doesn't infringe Wilson's free speech rights. He still had the ability to speak. This was they're just exercising their speech rights, expressing displeasure. City of Austin, Texas versus Reagan National Advertising could be much more important because it goes to a central question in current First Amendment jurisprudence. What's a content-based restriction on speech? The Supreme Court has said now for decades that content-based restrictions on speech have to meet strict scrutiny, whereas content-neutral restrictions only have to meet intermediate scrutiny. But when is a restriction on expression content-based? One way the court has approached this is to say, if it is a subject matter restriction, where the restriction of the speech depends on its topic, or if it's a viewpoint restriction, where the restriction depends on the ideology of the message, it's content-based. But if it's subject matter or viewpoint neutral, then it's content neutral, then it only has to meet intermediate scrutiny. But is that the right way of defining what content-based means? City of Austin, Texas versus the Reagan National Advertising involves a city ordinance that limits electronic displays on buildings. It says there can be a digitized display on a building only if it's advertising the business in that building. So I'm at the Berkeley Law School. If we had to operate under that, we could put a digitized ad outside or a digitized billboard for Berkeley Law School, but we couldn't rent the space to other businesses, nor can those businesses put up digital ads except for their own enterprise, not for anything else. Does this violate the First Amendment? The Fifth Circuit said that's a content-based restriction on speech. You have to read the ad to see whether the ordinance applies. You read the ad and you see it's for University of California, Berkeley School of Law, and it's permissible. Or you read the ad and see that it's for some other business that's impermissible. Isn't that really about the content of the speech? On the other hand, it's subject matter neutral. It's not really about the topic of the speech. It doesn't treat different topics in a varying way. It's not about the viewpoint expressed. Should this be seen as content-based? As I said, the distinction between content-based and content-neutral is so crucial, comes up so often. This is a key case, perhaps, in defining it. Charlotte versus Boston also goes to a key distinction with regard to freedom of speech, though it comes in a context where it's hard to imagine the court coming out but one way. The city of Boston has a flagpole, and it allows private groups to put their own flag on the flagpole briefly. And Boston allows all of these requests. It had granted hundreds of these requests until a group wanted to raise a flag that had a Christian cross on it. And the city said, no, you can't raise the flag with the Christian cross. The Supreme Court has drawn a distinction between when the government is the speaker and when the government is regulating private speech. If the government is the speaker, then you can't use the First Amendment speech clause to bring a challenge. But if the government is regulating private speech or has created a forum for private speech, then the First Amendment can be used to challenge this. Well, that's the question here. The United States Court of Appeals for the First Circuit said that the flagpole is government speech. And so therefore, there can't be a free speech challenge. Of course, what the challenger is saying is that no, the city has created a forum for private speech, for private entities to raise their flag, and so therefore the First Amendment applies. The last major Supreme Court case about this, you might remember, was Texas Sons of Confederate Veterans versus Walker. It involved the state of Texas allowing private groups to put insignias on license plates. And the Texas Sons of Confederate Veterans wanted to put a Confederate flag there. And Texas refused. A suit was brought. And the Supreme Court ruled in favor of Texas, saying that license plates are a form of government speech, and therefore you can't use the free speech clause to challenge their choices. I think the difficulty in this case is that in every other instance, Boston let any private group put its flag up. That all seems to be about Boston creating a forum for private speech. It seems that it's hard to say here that the flagpole is just the government speaking, which is what the First Circuit said. Case will be argued on January 18th. The fifth topic that I want to talk about concerns religion in the First Amendment. And there are two cases. One was argued earlier this morning. The case is Carson versus Macon. For decades, the issue before the Supreme Court was, when may the government give aid to religious schools without that violating the Establishment Clause? There were cases about, may the government give audiovisual equipment to religious schools? May the government give buses for field trips to religious schools? May the government provide sign language interpreters to religious schools? And in each instance was, is the government's choice to provide that aid a violation of the Establishment Clause? Now this has changed dramatically. Now the issue is, when must the government give aid to religious schools where it violates free exercise religion? This first arose just 4 years ago in Trinity Lutheran versus Comer. The state of Missouri provides aid to schools in the state for surfacing playgrounds. The state would provide the aid to all public or secular private schools. It wouldn't give the aid to religious schools. So the Missouri Constitution prohibited direct or indirect government aid to religious institutions. The Supreme Court, in a 7-2 decision, ruled against Missouri. Chief Justice Roberts wrote for the court, and he said, whenever the government gives aid to private secular schools, it must give that aid to religious schools unless the government can meet strict scrutiny. And he found that Missouri did not meet strict scrutiny here. Justice Sotomayor wrote a vehement dissent, was joined by Justice Ginsburg. She said, this is the first time in history that the court has ever held that the government is constitutionally required to give aid to religious schools. But Chief Justice Roberts mirrored the holding. In footnote 3, he said, this is just a case about aid for playgrounds. We know, though, that's not how Supreme Court decisions work. In June 2020, the court decided Espinoza versus Montana Department of Revenue. What was involved here is Montana passed a law that gave tax credits to people who gave money to a private school tuition organization. The tax credits were nominal, about $125. The Montana Supreme Court found that this violated the Montana Constitution. The Montana Supreme Court said virtually all the aid from this was going to go to religious schools, and the Montana Constitution had a provision that forbid direct or indirect government aid to religion. The Supreme Court, in a 5-4 decision, reversed. The Supreme Court said, in an opinion by Chief Justice Roberts, whenever the government gives aid to secular private schools, it must give that assistance to religious schools, unless doing so would violate the Establishment Clause. Well, this sets up Carson versus Macon that was argued today. It comes out of Maine. There are parts of Maine that are too rural to support a public school system. In those areas, the school administrative unit gives money to parents to send their children to private school. It affects about 5,000 children in Maine. Maine requires that the money be used to attend a secular school. It cannot be used for a sectarian school. The United States Court of Appeals for the First Circuit upheld this. 2 schools and 2 parents challenged it. Justice David Souter was on the panel of the First Circuit, sitting by designation. The First Circuit said any school, secular, religious, can leave the money, so long as its education is secular, that Maine has an interest in not subsidizing religious schools. Maine's interest is making sure that there's a secular education available to every student in the state. The challengers argue, in light of Trinity Lutheran and Espinoza, that for the government to be willing to allow the money to be used in secular schools, but not religious schools, violates free exercise of religion. The other case that deals with religion is Ramirez versus Collins. It was Collier, and it was argued on November 9th. It involves the administration of the death penalty in Texas. It involved a person who was about to be executed. And he wanted his clergy member to be able to be in the death chamber with him, to be able to pray out loud and to lay hands on him. Texas refused to allow the minister to say anything out loud at the time of the execution or to touch the person who was being executed. This came to the Supreme Court over the summer in a request for stay of execution. It came on the so-called shadow docket to the Supreme Court. The Supreme Court did something unusual. It took the case off the shadow docket and it put it onto the merits document, scheduled expedited briefing and argument. The case was argued on November 9th. And there really are 2 separate issues. Does the person being executed have a right to a clergy member who says prayers out loud? And does the person being executed have a right to have the clergy member lay hands on and touch the person? It might very well be that the court will do what Justice Kavanaugh suggested in oral argument, say there's a right of the clergy member to speak, but not a right to touch the person. Justice Kavanaugh is saying speaking doesn't interfere with the administration of the lethal injection, but touching the person might. I think that this case really puts against each other 2 important themes of the Roberts Court. On the one hand, the Roberts Court is very pro-religion. It is very receptive to claims, people, that the religious freedom is being infringed. On the other hand, the Roberts Court is very hostile to those who are facing execution, who are bringing challenges. And here we'll see how these 2 themes, when pitted against one another, come out in the Roberts Court. The final area that I want to talk about before taking questions concerns the Second Amendment. And the case is New York Rifle and Pistol Association versus Bruin. It was argued a month ago. I think it's important to put it in historical context. From 1791, when the Second Amendment was adopted, until June of 2008, not one federal, state, or local law regulating guns was struck down by the Supreme Court. There were only a handful of Supreme Court cases concerning the Second Amendment. And in all of them, the Supreme Court said, the Second Amendment means what it says. It's a right to have guns for purpose of militia service. But in June 2008, the Supreme Court decided District of Columbia versus Heller. It involved a DC ordinance that prohibited ownership and possession of handguns. The Supreme Court, 5-4, divided along ideological lines, struck down the DC ordinance. Justice Scalia wrote for the conservative majority, while Justices Stevens and Breyer wrote dissents for the liberal dissenters. Justice Scalia's majority opinion held that the Second Amendment protects the right of people to have guns in their home for the sake of security. The court didn't articulate the level of scrutiny to be used for the Second Amendment, but I think Justice Scalia was clear it's more than rational basis review. But he was also clear that the Second Amendment is not absolute. He said the government can regulate who has guns, like preventing people with a history of mental illness from having guns or prior felony conviction. The government can regulate where guns are located, like preventing guns in schools or airports. He said the government can regulate what type of weapons people have, such as preventing unusually dangerous weapons. It's interesting, from 2008 to now 2021, the Supreme Court didn't hand down another case about the scope of the Second Amendment. The only case about the Second Amendment in these 13 years was McDonald versus City of Chicago in 2010, which held that the Second Amendment applies to state and local governments. But the Supreme Court now has before it a very important case of the Second Amendment. It involves a New York statute. It was a law adopted over 100 years ago. It prohibits people from having a concealed weapon outside the home. It says in order to have a concealed weapon, a person needs to have a concealed weapons permit, and a permit will be granted only on a showing of necessity. A challenge was brought to this law. The federal district court upheld the law. The Second Circuit affirmed, and the Supreme Court granted review. There are so many important questions presented. Does the Second Amendment protect the right to have guns outside the home? Does the Second Amendment protect the right to have concealed weapons outside the home? How can the government regulate concealed weapons if there's such a right? What level of scrutiny should be used in evaluating government laws that allegedly violate the Second Amendment? I think from the oral argument, there's a majority to strike down the New York statute, but it's much less clear where the court's going to go. I think the court's likely to say that there's a right to have guns outside the home. I think the court's going to say there can be some regulation with regard to concealed weapons, but not clear how the court's going to draw those lines. It's not clear what, if anything, the court's going to say, what might be the most important underlying issue. What level of scrutiny should be used for the Second Amendment? If you think about the cases that I've talked about, 3 cases about abortion, a couple of cases about religion, case about guns, you can see why I say this is going to be a blockbuster term in the Supreme Court. And with that, I saved 10 minutes for questions.
Right on time. Our first question for you is, what other rights might be impacted if the legal reasoning behind Roe versus Wade is overturned? Or will the long-term impact be limited to abortion?
It's a great question. A lot's going to depend on how the Supreme Court writes the opinion. The Supreme Court has protected many rights that are not enumerated in the Constitution under the liberty of the Due Process Clause of the 14th Amendment. The right to marry, the right to procreate, the right to custody one's children, the right to keep the family together, the right of parents to control the upbringing of their children, the right to purchase and use contraceptives, the right of consenting adults to engage in same-sex sexual activity, the right to refuse medical care. If the court says that rights cannot be protected under the Liberty Due Process Clause unless they're enumerated in the Constitution, all of these rights would then be in jeopardy. And if the court doesn't explain what makes abortion different from all of these other rights, these rights will be in jeopardy. There was a wonderful op-ed in the New York Times last week by Charles Freed. He said he was the Solicitor General in 1989 when Webster versus Reproductive Health Services argued to the court. And he urged the court to overrule Roe versus Wade. And he said at that time he argued that it would be possible to pull the thread of Roe versus Wade out, but not unravel the rest of the rights. At least now he believes that inevitably overruling Roe would unravel the whole sweater, that pulling this thread out would then mean that all of these rights would be in jeopardy. I think we have a majority of the justices who are originalists or sympathetic to originalism. And I think it'd be hard for them to justify protecting these other rights once they've overruled Roe. So I am not sanguine in terms of the continuation of these rights in light of Roe, though the court may just regard abortion as different.
I have another one. And y'all feel free to put them in the Q&A or the chat, either works. Do you think that the Supreme Court will end up weighing in this term on the legality of the vaccine mandates that have been ordered by the Biden administration? What will they do with them?
I think it's possible. I think it's most likely, if it happens, to come up on the emergency docket of the court. Otherwise, I think it's going to have to come on expedited review. Right now, the challenge of the Biden mandate, which were brought in virtually every circuit, have been consolidated in the United States Court of Appeals for the Sixth Circuit. After the Sixth Circuit rules, it would then go to the Supreme Court. I think the Supreme Court will be asked either way on its shadow docket to issue a preliminary injunction. If the Sixth Circuit were to uphold the Biden mandate, I think the challengers would ask the Supreme Court for a preliminary injunction. I think if the Supreme Court were to strike down the Sixth Circuit would strike down the mandate, I think the Biden administration would ask for a preliminary injunction. And then it would come to the Supreme Court for full review. In order for the Supreme Court to hear it this term, it would have to be on expedited review, because the court will continue to grant cases for this term only until mid-January. This would seem the kind of situation that would justify expedited review. And there's so many issues as to how it could be presented. One is just in terms of, does the Occupational Safety Health Administration, OSHA, have the authority under the Occupational Safety and Health Act to promulgate such a rule? Another issue is, does a vaccine mandate violate the liberty of the due process clause? What about the need for a religious exception? There was a case coming out of Maine where Maine required its public workers to be vaccinated. There was no religious exception. The district court in the First Circuit upheld this. The Supreme Court denied a preliminary injunction, but 3 justices said they thought this was clearly unconstitutional. So you've asked me for a prediction. If I had to put my money down and predict, I'd say I think the Supreme Court does end up taking this case this term and on an expedited basis.
So the next question is about the TransUnion and Ramirez. And the individual asks, it seems to further commit the court to undermining Congress's ability to identify and elevate harms to being injuries in fact, by emphasizing the need to tie new harms to traditional wrongs already recognized by the court. Do you have any predictions for where standing doctrine is heading under this court?
I've said in a number of speeches that I regard TransUnion versus Ramirez to be the sleeper case from last term. Let me try and explain why. TransUnion versus Ramirez involved the Fair Debt Collection Practice Act. It imposes restrictions on credit reporting agencies to ensure accuracy and that they follow procedures. And the Supreme Court in a 5-4 decision said that in order to enforce a federal statute, federal court, in order to be standing, it has to be one that creates a right that has a close analog to a right that was recognized at common law historically. The Supreme Court has long said that Congress by statute can create rights, albeit rights that would otherwise exist. And the infringement of those statutory rights are sufficient harm for standing. Think of the Federal Freedom of Information Act. It says that every person has a right to all documents possessed by the federal government, unless they fit in one of 9 categories of exceptions. And it says anyone whose FOIA request is denied can bring a lawsuit challenging it. FOIA creates a statutory right, one that wouldn't otherwise exist, and the infringement of that statutory right is the basis for standing. But now TransUnion versus Ramirez says in order for a statute to create a right that's enforceable in federal court, it has to be a right that's closely analogous to what existed at common law historically. Well, common law historically, credit reporting agencies didn't have the duty to ensure accuracy, but nor was there a common law right or historic right to documents possessed by the federal government. Or think of Title II of the Civil Rights Act of 1964. There was hotels and restaurants from discriminating on the basis of race. Tragically, that's not a right that existed historically. It's interesting, the case I said was 5-4. Kavanaugh wrote, joined by Roberts, Alito, Gorsuch, and Barrett. Thomas wrote the dissent, joined by Breyer, Sinner, and Kagan. Kagan also wrote a separate dissent, joined by Breyer and Sotomayor. I wrote a law review article, it's in the NYU Law Review online, about TransUnion versus Ramirez and why I find it very frightening in terms of standing to sue in federal court.
And you're being thanked again for helping them pass the bar. I told you there's a lot of us. How do you think the Supreme Court will come down on the bounty decentralized enforcement system articulated by the Texas abortion statute?
First, thank you. And second, after the oral argument on November 1st, I thought the court was going to say there can be a suit against state officials to enjoin an unconstitutional law, even if they don't play a role in enforcing it. In oral argument, Justice Kavanaugh said, if a state can pass a law like this, why can't it pass a law that creates civil liability for anyone who performs a same-sex wedding? Why can't it create a law that says that there's civil liability for anyone who owns a gun, including legally? And both Chief Justice Roberts and Justice Kavanaugh said, and what if the fine is $1 million? Just saying you can violate the law and be sued and challenge the law as a defense isn't enough. Justice Barrett echoed this. So I thought in that case, it was going to be at least 6-3 to say that if a law authorizes civil suits for money damages, there can still be a constitutional challenge brought against government officials. But it's interesting, we're on December 8th and the court hasn't handed down a ruling. I was more skeptical as to whether the court was going to allow the United States government to have standing to sue. As I said in my remarks, I now wonder if the Supreme Court's going to overrule Roe and Dobbs and then say, therefore, the Texas law is constitutional and there's no need to decide the procedural issues regarding the challenge.
And we have a few questions around the shadow document about collegiality and the Supreme Court practices. One person said it's omerta, that, the mafia code, and the public perception of the court as a political institution. So can you speak to the shadow docket a little bit and those practices and the political issues?
The Supreme Court has always had the ability to issue emergency orders. Goes to the beginning of the Supreme Court. And they've often come up, say, in death penalty cases, when someone facing execution is seeking an immediate stay of execution. What happened during the Trump years is the Trump administration went much more often to the Supreme Court for a preliminary injunction or a stay of a lower court's preliminary injunction that was blocking Trump administration policies. The Trump administration went to the Supreme Court for such orders 3 times more in 4 years than the Obama administration had gone in 8 years. And increasingly important matters were being handled in these requests for preliminary injunctions. There were 4 cases in 2020 and in 2021 that involved challenges to governor's closure orders imposed to limit the spread of COVID. University of Chicago law professor William Bowd coined the phrase shadow docket for this. There's nothing sinister about the Supreme Court hearing requests for emergency orders. My criticism is that the Supreme Court has been very inconsistent. And also, and it's more technical, I don't think the Supreme Court has been following the usual rules of standards for appellate review. Generally, a preliminary injunction is to be overturned, stayed, or a preliminary injunction is to be granted when denied by the lower court, only on an abuse of discretion basis. And the Supreme Court isn't following that standard. In terms of politicization of the court's always been ideological in its decisions. Marbury versus Madison wouldn't have been decided the way it was, but for the ideology of John Marshall. Between the 1890s and 1936, the court struck down over 200 federal, state, and local laws protecting workers and consumers because of the ideology of the justices. But I think now with 6 justices, all conservative appointed Republican presidents, and 3 justices liberal appointed by Democratic presidents, the politicization seems much more salient. In terms of the justices and they're getting along, I don't think we can know. I think they're saying publicly we all get along. Doesn't necessarily tell us what's going on behind closed doors. The Supreme Court has its lowest approval ratings in history. A Gallup poll at the end of September gave it a 40% approval rating and a 53% disapproval rating. If the court overrules Roe, and 2/3 of the American people think it shouldn't be overruled, I think that's going to heighten the disapproval of the court. What that will mean in the long term is impossible to know right now.
Thank you so much for your excellent presentation and allowing us to ask you some questions and your thoughtful answers. I just really appreciate you. I'm going to have Will Vizota, our other chair of the event, kind of give you all some wrap up information that you might be needing about CLE and whatnot.
Thank you.
All right. Thank you, Dean Chemerinsky, and thank you, Grace. And thank you to everyone for attending this year's preview and to our sponsors for supporting our preview this year. As a reminder, this program has been approved for 1 hour of Tennessee CLE credit. You'll receive an email after this with instructions Please join the ACS Nashville chapter for our upcoming happy hour. It's currently set for January 12th, 2022. Check the Nashville Lawyer chapter emails in the coming days and weeks for more details. To donate to ACS, please use the link in your chat box. And finally, we'd love to hear from you. If you have any ideas for programming or would like to get more involved with our chapter, please reach out to us at acsnashvillechapter@gmail.com. Again, that's acsnashvillechapter@gmail.com. And again, thank you for attending. We look forward to seeing you at our upcoming events and next year's preview. Have a great rest of your day.